Hello and welcome to the Herrington Carmichael Employment Law Update for February 2018. My name's Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got 4 key topics to talk to you about this month. The first one is the taxation of termination payments and changes which are going to take place in April. This is quite a big change for those employers who do not have the reserved right to pay in lieu of notice within your contract of employment. You probably would know that if you have a contract that doesn't reserve payment in lieu of notice entitlements. And you would probably know that previously, at the current time and before April, you could potentially pay your notice as damages under the contract and that would not attract taxation. The law's changing in April though, which means that with effect from April, any amounts which is allocated toward a notice payment will have to be taxed, and that's regardless of whether you do or do not have the reserved right to pay in lieu of notice in the contract. So a bit of a niche change there, but could be quite important in relation to the way termination payments are treated by particular employers. Next, the case of Ruiz Conejero, which is a Spanish case involving indirect discrimination in relation to intermittent sickness absence. This is a fairly obvious case because what it effectively held is that where you're dealing with a disabled employee, you're going to have to justify your treatment of them where you're managing intermittent sickness absence. And that will be as a proportionate means of achieving a legitimate aim. It's a big risk factor area, and this has purely brought it back into focus by the European Court of Justice. So if you're managing disabled employees who are taking intermittent short-term sickness absence, please make sure you're being very clear about the application of an approach you're taking with them, and you've properly justified what you're doing. Third, the case of Malik and Senkos, which is a case arising from the Employment Appeal Tribunal in relation to whistleblowing. And in this case, what we see is where a person is treated detrimentally, the motivation of the person who treats the individual whistleblower detrimentally is key to the case as to whether it's going to succeed or not. This is putting in effectively an extra limb of evidence as to why somebody was treated detrimentally, and to be very clear that the motive is in relation to the original whistleblower. It's going to be a very particular set of scenarios, and we're going to be having to look very carefully at whistleblowing cases as to what the motive of an individual is, but it is an important change. Finally, the case of Crawford and Network Rail, which involves compensatory arrest in relation to working time regulations. As you'll know, in any 6-hour working period, an employee or worker is entitled to a period of 20 minutes rest. If they don't get that, they're entitled to compensatory rest. What this case says is that that has to be in one complete chunk of time. You can't spread it out, giving them a couple of minutes here and a couple of minutes there. It has to be in a complete period of time. That's it from me this month. And until next month, I hope you all have a good month, and I'll be back then. Thank you.